Hello, my name is Jamaal Jones, and thank you for taking time out of your day to look at the Jones Health Law YouTube page. Today, I'm going to discuss what are some of the options available to you if you've been wrongfully terminated from your hospital residency program. Now, of course, this will vary a little bit depending on what program you're in. If you're a pharmacist, you're governed by different rules. The ACGME wouldn't necessarily apply to you. So if you have specific questions for your practice area, please contact me directly. Provide you with a little bit of the contact information at the end of this video. So the long and arduous road to becoming a doctor is one that only a few people get to experience in their lives. Those few dream of becoming a doctor at an early age, which makes the journey seem that much longer. Your parent or your neighbor might have been a doctor, and that relationship might have created a desire to pursue the same career path. Maybe you were motivated by a desire to serve your community by providing health services to the poor or disabled. Unfortunately for you, your career as a doctor may come to a screeching halt before you complete your medical residency program. If you're at risk of being unceremoniously discharged from your residency program, or have already been discharged, there are certain legal considerations that you should examine. First, we're going to discuss the disciplinary board. Of course, every hospital, every institution is different in terms of how they structure any type of corrective action or appeals that the resident may participate in through that institution. If you're discharged from a medical residency program, it's important to examine the language contained in the hospital policies and procedure manual, and any code of conduct manual that might be available as well. In the manual, it will explain the procedure for internal disciplinary action taken against hospital staff, which may require a mandatory board hearing depending on the alleged infraction. Prior to the board hearing, a neutral intermediary may be utilized so that direct communication between the hospital and resident is limited. Again, this may vary a little bit. Some hospitals are very large, others are very small. So they may not necessarily have all these different channels and things in place to deal with board reviews or termination of a medical resident. The disciplinary board may be comprised of a 3-person panel where you can choose to present your defense. I would advise against signing any documents presented to you by the hospital after you receive written notice of the disciplinary hearing until you've spoken to an attorney with experience in health and employment law. Many times they'll even tell you, well, you can't leave the room until you sign this. I promise you that you can get up and you can leave the room without signing anything. You do not want them to force you to sign anything until you've had the opportunity to speak to an attorney. The manual will state how many days the panel has to render its final decision, typically, regarding your status in the hospital residency program and the method by which the panel will use to render the final decision. There will also be a procedure for filing a timely appeal should you choose to do so after an unsuccessful initial board hearing. Now, determining whether suspension, termination, or resignation is the appropriate path for you. The panel may recommend suspension or termination from the hospital residency program. The length of the suspension will vary depending upon the circumstances. A board's decision to suspend or terminate a resident should be determined objectively, but it's difficult to refute the fact that there is a subjective component. This is why one resident who committed similar bad acts may only be suspended while another resident may be terminated. Hospitals have the authority here to make the determination, and unless there is clear employment discrimination, a court is unlikely to undermine or overthrow the hospital's decision. In some instances, I have witnessed the hospital allow the resident to voluntarily withdraw or resign from the hospital residency program so that it doesn't diminish their chances of gaining acceptance to another residency program. The thought of starting anew in a different residency program is chilling, but given the circumstances, this could be your best option. You must decide whether you want to explain why you resigned from the program, or you can let the records speak for themselves. If you elect to be terminated from the program and subsequently apply for admission into a different program, you'll be required to submit your records from your previous residency program. Additionally, the hospital residency program may ask for references where the details of your departure may come to light. Further, the hospital manual should be examined alongside your hospital residency employment contract. Now, let's segue into whether you should pursue arbitration, a lawsuit, or an administrative complaint, if any of these are available to you. Your residency employment contract will contain the terms and conditions of your employment during the residency program. The contract will most likely bind you to a mandatory arbitration in the event that a legal matter arises between you and the hospital, and it can be dispensed with in the appeal process within the institution. Hospitals prefer arbitrations for several reasons. Some of those include they're usually less expensive. The parties can choose the arbitrator instead of one judge being assigned to you by the court. Parties can choose the time and place of the arbitration. The proceedings are held privately behind closed doors, and its outcome does not become part of the public record. Arbitration is not held in court, but in a court-like setting, complete with discovery proceedings and an arbitrator acting as a judge. Additionally, the arbitration is resolved much faster since the parties don't have to wait for availability on the court's docket, which can take months before you are actually heard by a judge. Final judgment by an arbitrator is binding and very difficult to successfully appeal. Depending on the reasons why you were fired, you may be able to file a complaint with the Accreditation Council for Graduate Medical Education, which is an organization that in part helps physicians in graduate medical education receive fair solutions to residency or fellowship education related concerns and formal complaints. Most residency programs are accredited, if not all, by the ACGME. The ACGME requires that residents have a right to present their defense before a board or panel. The ACGME's Resident Science Services Division does not adjudicate disputes between individual persons and residency or fellowship programs or sponsoring institutions. Resident Services does not address issues regarding matters of administration, admission, appointment, contract, credit, discrimination, promotion, or dismissal of faculty members, residents, or fellows. As such, depending on the facts and circumstances, I advise residents against filing a lawsuit against the hospital unless you are terminated for an illegal reason. Illegal reasons can include but are not limited to discrimination based on race, gender, sexual orientation, country of origin, nationality, or religion, and of course for harassment. You may make a claim alleging discrimination under Title VII of the Civil Rights Act of 1964 and breach of contract if the facts support such a claim. In cases where residents have successfully won lawsuits against the hospital for discrimination, they introduced ample evidence from which it could be concluded that they were unlawfully discriminated against. Residents may try to obtain evidence of the following: testimony or an affidavit from doctors in a direct supervisory position to attest to the satisfactory nature of your work, evidence to rebut the supervisor's negative evaluations of you, the resident, evidence of other residents with low test scores or unfavorable evaluations who have been allowed to continue within the program, and evidence that you were able to successfully complete the residency program since leaving the hospital. In some jurisdictions, direct evidence of discrimination is not required. A plaintiff may be entitled to rely on circumstantial evidence to convince the trier of fact that an employer's explanation of his discharge is pretextual and that his or her discharge was more likely than not motivated by discriminatory intent. However, more of today's courts are less likely to rule in a resident's favor unless the resident can show direct evidence of discrimination. Dr. Zaklima, in Zaklima versus Mount Sinai, was able to obtain evidence of examples A through D that I just referenced above in terms of providing or coming up with evidence, but it took approximately 6 years for the case to be fully adjudicated, and a lot of money was spent in legal fees. Regardless of whether you go before a hospital board, an arbitration, or file a complaint with the ACGME, you will have the opportunity to review your evaluations, personnel file, and credentialing so that you can build your defense. If you feel that you're at risk of being removed from your hospital residency program and would like to speak to an attorney about your options, please contact me immediately. You should explore all of the options available to you because this is your career at stake. There's typically a very short window to file an appeal, so it's imperative that you contact your attorney immediately if you're facing a disciplinary board hearing at your hospital. My name is Jamaal Jones. I'm the principal attorney for Jones Health Law. If you'd like to find out more information about this or any other topics, please don't hesitate to contact me at 305-877-5054, or you can email me at jrj@joneshealthlaw.com or visit our website at www.joneshealthlaw.com. Please follow us on Facebook. Our page is Jones Health Law. You just search there, or you can follow us on Instagram at Jones Health Law. Thank you very much for taking the time to look at this YouTube video.